Let's go back to the contractor. They finished the project, but they haven't been paid by the owner. What to do?
Before your final inspection, before the owner puts blue tape all over the place, when did you feel like you finished the job, but for just tying out the loose ends? You just don't want to be wrong, because the 90-day deadline is a hard and fast deadline that can't be continued.
Hello, this is Chip Bachara with Bachara Construction Law Group, a Florida law firm with offices in Jacksonville and St. Petersburg. And with me today is Hugh Higgins, managing partner of the St. Petersburg office. Hi, Hugh.
Hey, how's it going, Chip?
I'm doing good. So, Hugh, now let's get back to the concept of the claim of lien. We talked about a contractor who's in privity and then subs and suppliers who are not in privity. Let's go back to the contractor. Now they finished the project, but they haven't been paid by the owner. What to do?
Well, you have a 90-day clock ticking from the last day of work on the project, and that's a term of art that's been interpreted by a lot of courts in Florida, but it's typically not interpreted the way most contractors would interpret the last day of work, right? Most contractors that I talk to would assume the last day they finished out their punch work is the last day on the job, or maybe the final inspection is the last day on the job, right?
It seems obvious. It's called last day of work. What can be complicated about your last day of work? So tell us about that.
Yeah, so last day of work has been interpreted by the courts as, let's call it the last day of substantive work. Before your final inspection, before the owner puts blue tape all over the place, before the creation of the punch list, when did you feel like you finished the job, but for just tying out the loose ends and doing your inspection to get your certificate of occupancy? That's what I typically ask the client, and ask them to be cautious, to be conservative, to go back in time rather than aggressively, forward in time, because you just don't want to be wrong, because the 90-day deadline is a hard and fast deadline that can't be continued.
Yeah. And in fact, with regard to what that work is, to determine whether it was your last day on the job, we say, as you referenced, Hugh, punch list work is not considered last day on the job. That's work that's considered de minimis or insignificant to the contract. If it's something, however, that you needed to perform in order for your part of the contract to be complete for the first time through, because punch list work is usually, there's little errors or blemishes that need to be taken care of, but you've really done the work. But if there's work that you haven't done that is required to be done under your contract, then once you've finished that scope of the work, I would say that would be your last day on the job. If you felt like you could submit your application for final payment before punch list or substantial completion, and the owner would say, or the contractor would say, yes, you've done that. Now it's time for the punch list and the final completion. That's when the 90 days begins to run. There is actually a legal test that courts have put out, probably came out about 30 years ago, where they give a description. And the reason for that is people thought they would get clever, and they show up out of the job site. They climb up on a ladder somewhere and get a picture of themselves that says, and you'll recall the old cameras that used to put the date on it. Now that's stamped on the on the media that's there. But at any rate, they say, no, look, I was out on the job this date. Well, wait a minute. Why did you request payment 4 months before that if you were still doing work that was necessary? You seem to think you were done on this job, 100 days ago, not 90 days ago, when you asked for, that you asked for payment. And so those tricks most of the time do not work. And so you have to be careful about making sure you get it within the 90 days, because if you lose your claim of lien, there are some problem that you can run into some financial difficulties with that, and we'll talk about that in a little bit. Claims of lien are complicated. It's a really strong right that's been given, but the person or entity filing the claim of lien has to take care of all the detail. So we talked a little bit about that in the way of the notice to owner for those that are not in direct contract with the owner, and we talked a little bit about when they're in direct contract with the owner. Let's talk a little bit about the claim of lien itself and what needs to be included. And in particular, the really dangerous part is when you start talking about the amount of your claim of lien. So let's talk a little bit about that, Hugh. What happens when you have to calculate that amount of the lien?
Yeah, so filing a claim of lien is a sworn statement, first and foremost. And it's regulated by the lien law statute, which has a very specific template of the information that needs to be plugged in. Basic things like who the owner is, where the property is, who the contractor is, what their scope of services is. And then you get into the key detail. When was your first day of work? When was your last day of work? What was your total contract amount for? What's the total amount that you provided? And what's the total amount that has been paid, left unpaid? And those are the key bits of information that we should focus on. Where it gets complicated is where there's a dispute about whether the contract allowed a specific scope of work to be performed for the amount that the contractor contends it was performed for. So let's say the owner believes that something was part of the contract and the scope of services, but the contractor believes it's a change order and that their entity is entitled to additional funds. You really want to be on the side of caution as the contractor, because if a contractor aggressively includes additional amounts it's claiming in its claim of lien that it doesn't have a solid contractual basis for, there's something called a fraudulent lien. And contrary to what you would typically think a fraudulent lien is, something that's just blatantly a lie or a scheme or some fill in the blank of what you consider fraud. A fraudulent lien is really more either a willful exaggeration or should have known it was so wrong that you shouldn't have included it. And when you get into the should have known it was wrong and you shouldn't have included it, there's a whole gray area of what that could be considered. And as you might imagine, in litigation, two different parties take widely different views on whether something is rightfully included or wrongfully included. And so a contractor could have a very good faith basis for including something in the claim of lien, while the owner thinks it's just absolutely a fraudulent lien. And so, in this 90-day window, or 30-day window, or 15-day window, whenever it comes to counsel's office, you have to make some key decisions about what happened on this job, what the scope of the contract involves, and what amounts are rightfully included in the claim of lien. You have to be careful to weigh leverage versus the strength of your claim of lien, because if you go too far and you use your claim of lien to leverage out a large amount, you could actually end up completely negating the claim of lien, being responsible to the other party for their attorney's fees, and being responsible for the other party for what we've referred to as punitive damages associated with a fraudulent lien. So, that can go real sideways.
So there's one more step that has to be taken before a contractor that's in privity with the owner can file suit on the claim of lien. And that is to serve what's known as a contractor's final affidavit. That's a document that tells the owner all the subs and suppliers that have not yet been paid. If you're putting that together, there's some nervousness to think, well, I don't really want the owner to know who I haven't paid yet. But you have to. You have to identify each one, because that way the owner can look and say, well, I'm not going to pay you. I'm going to pay all these subs and suppliers of yours. And they're allowed to do that under the law. That makes sure that they get paid. There are other steps that can be taken, but the contractor's final affidavit, and this is critical, it has to be served not less than 5 days before you file your lawsuit to foreclose on the claim of lien. Now, when you're the one that's going to prepare to file the lawsuit, you know when you're going to file that lawsuit. But if all of a sudden you get a 20-day notice that says you've got to foreclose on your claim of lien, it's June 1st, and you've got to have the suit filed by June 20th, that means before June 15th, you have to serve that contractor's affidavit. And that in the rush to get things done, that's often forgotten, and that negates the entire claim of lien. So it's really critical that you be aware of those obligations, all of the hoops that you have to jump through that we've talked about, and that you make sure they're taken care of. That's another reason that you want to get your lawyer involved as early as possible, because those are some of the details that have to be taken care of. It's also important that you get a lawyer that knows the construction lien law, because there are so many problems, so many difficulties and details with this. Lawyers, like their clients, can get into trouble. They can stumble on those if they're not familiar with it. When you're in a situation where you need to protect yourself from getting for your payment and to recover payment, and you're not allowed to go and take back the work that you've done, if once it's incorporated to the property, you cannot do that under Florida law. That's a good time to call a lawyer and evaluate. Make sure the lawyer is evaluating the economics of the situation for you. We do that with every phone call that we receive, and we talk about the amount in dispute and what it might cost to do that. And I think it's important that happen. If you find yourself in that situation, give Hugh or myself a call. We'll be glad to help you out and get you set on the right track for recovering that payment. Thanks very much.